subpoena. So bottom line, let the investigation continue, but let's acknowledge that the job that the committee needs to do before it asks for a vote of contempt has not been done. I yield back.
Gentleman's time has expired. Gentleman from Florida.
Mr. Speaker, I yield 2 minutes to the gentleman from Texas, Judge Poe.
Gentleman from Texas is recognized for 2 minutes.
I thank the gentleman. Mr. Speaker, we are here today because of an ill-conceived, dangerous, illegal gun-running scheme called Operation Fast and Furious. This operation has resulted in the death of at least one, maybe two federal agents, and in the death of hundreds of Mexican nationals. Yet we still cannot get a straight answer from the Justice Department as to what happened. The Attorney General says he doesn't know who authorized this nonsense, but he won't let Congress help him find out the facts. In December of last year, Attorney General Holder testified before the House Judiciary Committee and told me that Operation Fast and Furious was flawed and reckless, and that it was probably true more people are going to die. Now, isn't that lovely? Why is the Attorney General being so obstinate? After months of delay, today is the day of reckoning. This administration claims to be the most transparent administration in history. So why won't the administration let the American people know what happened during Fast and Furious? What are they hiding? This contempt resolution is about one thing. It's about finding out how such a stealth and dangerous operation could ever be authorized by the government of the United States. Why would our government help smuggle guns to our neighbor and put them in the hands of the enemy of Mexico and the United States, the violent drug cartels? And no wonder the Attorney General of Mexico wants those in the United States who are responsible to be extradited to Mexico and tried for those possible crimes. Mexico is more interested in Fast and Furious than our own government. As a former judge, I can tell you that contempt is used as a last resort to let individuals know they will comply with a lawful order whether they like it or not. Even the Attorney General cannot evade the law. Time for America to find out the truth about gun smuggling to Mexico. Time for a little transparency. Today is Judgment Day, and that's just the way it is.
Gentleman's time has expired. Gentleman from Massachusetts.
Mr. Speaker, let me remind my friend that this gun walking program started under President Bush, and that's just the way it is. And I'd like to yield 15 seconds to the gentleman from Texas.
Gentleman from Texas is recognized for 15 seconds.
Thank you, Mr. Speaker. Members, I'm from Texas, and we believe it's our constitutional right to own every gun that was ever made, and we don't want to export them to anywhere. But this resolution is pure politics, and I ask unanimous consent to place my statement in opposition to the record.
Without objection. Gentleman from Florida.
Mr. Speaker, I yield 2 minutes to the gentleman from Florida and a former law enforcement officer who lost her husband in the line of duty in Florida.
Gentlelady from Florida is recognized for 2 minutes.
Thank you, Mr. Speaker. And I'm going to come to you from a different angle, one of a law enforcement officer. I served over 17 years as a law enforcement officer. I worked many undercover operations. And as a law enforcement officer, we knew you don't give guns to bad guys. The drug cartels, they're bad guys. You know, if you let a gun walk with a bad guy, you're going to see that gun, whether it's at a crime scene or you're going to be looking down the barrel of it. So when the Attorney General came to our committee, I asked him, who approved this operation? Why was it approved? And he said he just wouldn't answer. He didn't know. Okay, well, what rises to the level of the Attorney General if an international operation that allows guns to walk to another country and are used to kill one of our agents and used to kill and maim their citizens doesn't rise to his level of approval? Who approved it? This is something that is just normal procedures in a law enforcement agency, in any operation. So now you have an Attorney General who won't tell us or can't tell us who approved this international operation. You have others saying, well, this is something that started under another administration. Well, it didn't. That was a different operation that they realized they couldn't keep up with those guns, so they stopped it. And this one started, it was flawed from the beginning. The Attorney General said it was flawed from the beginning, and yet we still have no answers. We don't have answers, the American people don't have answers, and most importantly, the Terry family doesn't have answers, and that's just unacceptable. Let me just say this. I've heard from the other side of the aisle and from my colleagues here today that this is political. This isn't political. To me, it's personal. We have a law enforcement officer doing his job who was killed by a flawed operation that no one will take ownership of in the Attorney General's office, and the Attorney General himself won't tell us what rises to the level of his knowing what's going on in his agency if an international operation does not. So I would tell you this. It was not political when I started looking into this, and when we started looking into it, it is not political today. And the way that it became political was when it was asserted right before the gavel dropped in the committee an executive privilege.
Yield an additional 15 seconds if you'd like.
The gentlelady is recognized for an additional 15 seconds.
I ask you today to approve this resolution. Bring some credibility back to our Department of Justice. This Department of Justice, if it had happened in another agency throughout this nation, and one of our officers had died and the Department of Justice was involved in the investigation, they would be asking for the same documents that we are asking for.
Gentlelady's time has expired. Gentleman from Massachusetts.
Yeah, Mr. Speaker, let me just say to the gentlelady that if she's interested in why the United States pursued this gun-walking program, she should talk to the Attorney General under the Bush administration, Attorney General McCasey, where this thing started 5 years ago. And unfortunately, notwithstanding the fact that the Democrats have asked that he be called before the committee, their requests have been denied.
Will the gentleman yield?
She wants to know why this is political. Every single witness that the Democrats asked to be brought before the committee were denied. Every single witness.
Will the gentleman yield?
No, I will not. That is unprecedented in this House, in any committee. And the fact that the Democrats have been locked out of having any of their witnesses come forward, this is not about gun walking. This is not about finding the terrible truth about what happened to Agent Terry. This is about politics, plain and simple, and it diminishes this House. I'd like to yield 2 minutes to the gentleman from the District of Columbia, Ms. Holmes-Norton.
The gentlelady from the District of Columbia is recognized for 2 minutes.
I thank the gentleman for yielding. Any doubt that today's contempt resolution is political was put to rest when the NRA joined in to blowtorch vulnerable Democrats to vote for contempt today. The gun lobby is directly responsible for the gap in federal law that allowed straw purchases of guns here that were sold in Mexico, and ultimately for the tragic death of a border agent. Yet our committee spent no time on the root cause of the tragedy because of a political mandate from the gun lobby. Instead, after the majority failed to get documents it requested under court seal and documents related to ongoing investigations, it asked for internal communications that no Republican or Democratic administration has ever given up. Instead of sparing no effort to give law enforcement the tools they must have to protect our border agents, our committee has spared no effort to get to today's contempt resolution over issues unrelated to the tragic killing. After 16 months, the committee found no evidence that the Attorney General or other top Justice Department officials knew about the ATF gun walking, and the committee resolutely refused to hear from top ATF officials who said that they, in turn, had given the Justice Department no such information. It is Attorney General Holder who stopped the gun walking, authorized, and started by the Bush administration. The contempt today, Mr. Speaker, is for the truth. And I yield back the balance of my time.
Gentleman from Florida.
Mr. Speaker, I just want to make it very clear. The House Rules, Article 11, talk about specifically J1 as it relates to the rights of the minority. But you have to ask for that, as a majority of the minority have to ask for it, and it has to be focused on the issue at hand. They were talking about issues as related to gun ownership. And that was not germane to that issue. And so with that, I yield 2 minutes to the gentleman from Arizona, Mr. Quayle.
Gentleman from Arizona is recognized for 2 minutes.
Thank you, Mr. Speaker, and I thank the gentleman for yielding. Mr. Speaker, today's vote is long overdue. For months, my colleagues and I have worked to uncover the truth about Operation Fast and Furious, which cost the life of Border Patrol Agent Brian Terry in my home state of Arizona. Congressional efforts to get to the bottom of this tragedy and bring accountability to those responsible were met with derision by Attorney General Holder. At hearings when we questioned, Mr. Holder evaded. When we requested documents, he obfuscated. When I questioned Mr. Holder on June 8th, he looked me in the eye and stated plainly that there was nothing whatsoever in the wiretap applications that suggested the existence of a gun-walking program. Yet all I had to do was review those same applications to see that what the Attorney General had said to me, my colleagues, and to the American people was nothing but a bold-faced lie. Mr. Speaker, I will repeat that again. It was a bold-faced lie. Today, let Congress's vote be a signal to Mr. Holder that dishonesty on the part of the administration officials will never be tolerated. Today, let this vote be a signal to President Obama that the security of the American people must always come, but for his own job security and the job security of his cabinet officials. Let this vote be a reminder to Mr. Holder and to President Obama that despite their executive overreach, there are in fact 3 co-equal branches of government. Let this vote demonstrate that Congress has not forgotten its right or its responsibility to provide oversight and to bring accountability. I urge my colleagues to support the rule and the underlying resolution. Thank you, Mr. Speaker, and I yield back the balance of my time.
Gentleman yields back. Gentleman from Massachusetts.
Yeah, Mr. Speaker, my colleague from Florida, Mr. Nugent, mentioned the issue of gun ownership and as related to the witnesses that the Democrats wanted to have appear before the committee. How inviting the head of the ATF, which is responsible for this, the Operation Fast and Furious, or inviting the former Attorney General who was briefed on gun walking and knew about it, how that has anything to do with gun ownership? What that has to do with, Mr. Speaker, is getting to the truth. And the minority has submitted a request for witnesses in writing, and even requested for which I guess they have the right to do, a day of minority witnesses, which they were told that they would not be granted that day in a timely fashion. So this is about politics. This by all measures is about politics. And again, the fact that we are doing this today, I think, diminishes the House of Representatives. I yield 2 minutes to the gentleman from New Jersey, Mr. Andrews.
I ask unanimous consent to revise and extend my remarks.
Without objection, gentleman is recognized.
Speaker. Every member of this chamber wants to get to the bottom of the issue of the tragic death of Officer Terry. And every member of the chamber wants to find out how the ATF and Justice Department were run as related to that tragedy. So the committee that's looking into this refused to hear the testimony of the person running the ATF. And the committee that's looking into this refused to hear the testimony of the Assistant Attorney General, who was responsible for the ATF and talked about this with Attorney General Holder. The committee that is responsible for this received thousands of pages of documents from the Attorney General to try to get to the bottom of the matter. This procedure does violence to the American Constitution. Yes, we have 3 separate branches. Those branches are designed to respect each other's prerogatives. Those branches are designed to avoid a constitutional confrontation and engage in one only when necessary. In the 225-year history of this institution, There has never been a vote like this one before. Never. Is it because the Attorney General didn't turn over documents? He turned over thousands of pages of documents. Is it because the people that know about this issue haven't been made available? To the contrary, the committee refused to hear the testimony of the head of the ATF and the Assistant Attorney General. This procedure diminishes the House. It vandalizes the Constitution. It should not go forward. I yield back the balance of my time.
Gentleman yields back. Gentleman from Florida.
Mr. Speaker, I yield 30 seconds to the gentleman from Utah, Mr. Shevitz.
Gentleman from Utah is recognized for 30 seconds.
Thank you. The record will reflect that in a bipartisan way, the acting director of the ATF, the person that was actually appointed by President Obama, was deposed by both Democrats and Republicans about a year ago over July 4th, 2 days that he was deposed. That record is there. It is crystal clear. We were also denied by the Department of Justice to speak with Lanny Brewer and Kenneth Blanco, two of the key central people at the highest levels of the Department of Justice. So to suggest that we were given an opportunity to talk to them is patently false. And the final point I will make is you can't complain that the Attorney General Holder was here 9 times between the House and the Senate talking in part about Fast and Furious and then say that you never had a Democratic witness. Yield back.
Gentleman yields back. Gentleman from Massachusetts.
Yeah, Mr. Speaker, we need to deal with facts in this debate because this is an important matter. And the gentleman just talked about these hearings, these meetings with the head of the ATF. The reality was that a year ago, Republican staff met with the head of the ATF on July 3rd without notifying Democratic staff. Democratic staff were invited to come on July 4th. There were no public hearings, and no members were there. So, again, I'm not sure what the problem is with having the head of the ATF come before the committee so the American people can hear what the truth is and what the facts are. I don't know why that's such a big deal. But to suggest that this was a bipartisan effort is just outright false. Mr. Speaker, this time I yield 2 minutes to the gentleman from Maryland, Ms. Edwards.
The gentlelady from Maryland is recognized for 2 minutes.
Thank you, Mr. Speaker, and I ask permission to add my comments to the record.
Without objection.
Mr. Speaker, the Republican majority is pursuing an unprecedented and a partisan constitutional confrontation today, and it's unnecessary. The contempt resolution that's before the House is both disgraceful and it really is demeaning to this House. It's being brought forth by the other side simply to drag Attorney General Holder through the mud and to publicly accuse him and the administration, and frankly, by extension, the President of the United States, of a cover-up, claiming that our Attorney General was obstructing justice. Republicans even went so far to call him a liar on national television. This is unheard of, it is hyperbolic, and it's disrespectful to the office and disrespectful to this House. The fact that Chairman Issa and Republicans have continuously moved the goalposts and disregarded the good intent and good faith shown by the Attorney General, the Justice Department, and the President's administration. As has been said before, the Department of Justice has provided the Congress with over 7,600 pages of documents and made numerous officials available for testimony. But that's been rebuffed. And just last week, the Attorney General offered to provide even more internal documents and requested a show simply of good faith on the part of the Republican majority that they wanted to resolve the contempt issue, but they've refused, choosing this constitutional confrontation instead. And that's because the Republicans, to be clear, are not interested in a resolution. They're not looking to compromise. They're only looking to score political points at the expense of the integrity of the House and the good name of the President and the Attorney General. And so I would ask us to carefully consider what we're doing here today and to raise into question what we're doing to this House, to the institution, and to the presidency. And I would ask my colleagues on the other side of the aisle to ask themselves whether the American people want us to focus on their business, to focus on the business of moving the country forward, or to simply play politics because you can't win any other way. And it's a really simple proposition that's in front of us today. And I would say to my colleagues on both sides of the aisle, it is time for us to simply walk away from the nonsense that is not doing justice to the American people. And with that, I yield.
time has expired. Gentleman from Florida.
I'd like to inquire how much time is...
The gentleman from Florida has 9½ minutes remaining. The gentleman from Massachusetts has 10 minutes remaining.
I continue to reserve.
Gentleman reserved. Gentleman from Massachusetts.
Mr. Speaker, I'd like to yield 2 minutes to the gentleman from California, Mr. Schiff.
Gentleman from California is recognized for 2 minutes.
I thank the gentleman for yielding, and I rise in strong opposition to this resolution. What began as a legitimate investigation into an operation called Fast and Furious has unfortunately degenerated into yet another partisan political attack in an election year. And it's a shame this has taken place for many reasons. First and foremost, because the American people have a legitimate interest in getting to the bottom of the gun violence that spills across our border, of the tens of thousands of weapons made in America that end up in the hands of the cartels. But instead of looking into this investigation, instead of finding out what we can do about this gun violence, this has now become a fight over documents, a fight that is completely unnecessary and unjustified. The very documents that are at issue in this resolution were created after this operation had long since been shut down. They will shed no light on the operation. They will shed no light on what we can do to stop this gun trafficking. But then that's not the goal. The goal here is simply the fight. The Justice Department has bent over backwards, produced thousands of documents. The Attorney General has testified 8 or 9 times before the House, has made every effort to cooperate in this investigation, but the committee will not take yes for an answer because that's not the goal. The fight is the goal. And so we are here when we should be doing the nation's business, when we should be working on legislation to create jobs. Instead, we are here in what is nothing less than a partisan brawl over nothing. And you know how this will end? It will end months or years from now with a settlement in federal district court in which the Justice Department will provide the very same documents they have already offered to provide. But we will have wasted our time, we will have wasted our money, and we have wasted the precious opportunity to get the people's business done here in the House. In case the majority hasn't noticed, we are in the midst of a very difficult economy where people are struggling to find work. They're not struggling to find another partisan fight on the House floor. This is something that cried out for resolution, but those cries were ignored. I urge a no vote.
The gentleman's time has expired. Does the gentleman from Florida reserve?
Mr. Speaker, I yield 2 minutes to the gentleman from Utah, Mr. Chaffetz.
The gentleman from Utah is recognized for 2 minutes.
Thank you, Mr. Speaker. The reason I'm so passionate about this issue is that it's about openness, it's about transparency, it's about the idea that there is no one person in our government that's above the law. That when you have a duly issued subpoena, you comply with that subpoena. In fact, I'd like to hearken back to the remarks by President Obama as he took office. He said, quote, "Let me say it as simply as I can. Transparency and the rule of law will be the touchstones of this presidency. I will also hold myself as president to a new standard of openness. But the mere fact that you have legal power to keep something secret does not mean you should always use it." He went on to say, "I expect members of my administration not simply to live up to the letter, but also the spirit of this law." He went on to send something to all of the department heads. He said, quote, "Government should not keep information confidential merely because public officials might be embarrassed by disclosure, because errors or failures might be revealed, or because of speculative or abstract fears," end quote. The President further said, quote, "There may be a situation here in which a serious mistake was made, and if that's the case, we'll find out and we'll hold somebody accountable," end quote, relating to Fast and Furious. We have a dead Border Patrol agent. We have over 200 dead Mexican people. We have a program that the Attorney General called as fundamentally flawed. We have thousands of weapons that are missing. We have a duty, an obligation to pursue this to the fullest extent and to make sure that we have all those documents so we can make sure that it never, ever happens again. Now, there are 140,000 documents, according to the Attorney General, that deal with Fast and Furious. We've been given less than 8,000 of those. Less than 8,000 of those. We deserve to have that. I would also, under general leave, I will be leaving this statement from the National Border Patrol Council. This is the AFL-CIO-oriented organization, 17,000 Border Patrol members who call for the resignation of Attorney General Holder. In fact, they say that a slap in the face to all Border Patrol agents who serve this country, an utter failure of leadership at the highest levels of government. If Eric Holder were a Border Patrol agent, not the Attorney General, he would have long ago been found unsuitable for government employment and terminated. These are from the people on the front line. We have an obligation to get to the bottom of this. I yield back.
Goes back. Gentleman from Massachusetts.
So 15 seconds.
Gentleman is recognized for 15 seconds.
Mr. Speaker, if this is about openness, then why does the committee have secret meetings where they lock Democrats out? If this is about openness, why won't they let any Democratic witnesses appear before the committee? And since there seems to be some confusion as to whether or not Democrats actually formally requested witnesses, I'd like to ask unanimous consent to insert in the record a letter to the Honorable Darrell Issa on October 28th, on November 4th, on February 2nd, requesting witnesses including the Attorney General, former Attorney General McCasey, and Mr. Melson, the head of the ATF.
Will the gentleman yield
at this point, I'd like to yield 2 minutes to the gentleman from Georgia,
will the gentleman
Mr.
yield?
Johnson.
Gentleman from Georgia is recognized for 2 minutes.
Thank you, Mr. Speaker. Today, we need to understand that there are two types of documents that, or two classes of documents, the ones that relate to pending criminal investigations. Those are not discoverable or cannot be distributed outside of the Justice Department under penalty of U.S. law. You can get 5 years for doing that. You can't expect the Attorney General to turn those over. The other class of documents, internal communications. There may be some whiff of discoverable information in those, but they're covered by executive privilege, and you really don't know why the Attorney General has invoked executive privilege on those issues, but we have to trust the fact that there's good reason for that to be the case. Now, when you compare what has gone on today and over the last 7 days with what happened the day that President Obama was sworn in, you can understand why they're doing what they're doing today. You see, not very long after President Obama was sworn in, we got word that Mitch McConnell said that his mission was to make President Obama a one-term president. And then we know that later on that afternoon, later that evening, when everyone else was enjoying themselves at the presidential balls, there was a group of congresspeople, leadership in the Republican Party, that were scheming on how they were going to disrupt and say no and obstruct everything that this president put forth. And so they have done that. They have done everything they can to make this president look bad. This is a manufactured crisis. It has no legal substance whatsoever. This is just simply a cheap political stunt to bring disfavor upon the President of the United States. And I ask my colleagues to not let us sink to this level. The first time in history that any cabinet member has been found in contempt of court.
Time has expired.
This is truly saddening, and I yield back.
Gentleman from Florida.
Mr. Speaker, I yield 90 seconds to the gentleman from Oklahoma, Mr. Lankford.
Gentleman from Oklahoma is recognized for 1.5 minutes.
I would have to concur. This is an incredibly sad day. This administration that started talking about transparency has now sunk to the level of actually concealing documents. Never has an Attorney General been held in contempt of Congress because every other Attorney General has turned over documents to Congress when they were requested. This Attorney General has not. Now just compare this whole controversy on the Secret Service scandal from several months ago. They put everything out, released all the documents, walked through it, it was done. The GSA scandal, released all the documents, held people accountable, it was done. ATF, even when we started this investigation a year and a half ago, put all their documents out, put all their people out, done. As soon as we get to the Department of Justice, it's slow, it's delay, it's delay, it's delay. The question is why? Why this matters that we get to the Department of Justice in the documents is because in Phoenix office, everything was organized in the Phoenix office, then was approved by the U.S. Attorney in the Phoenix area, and then went to the Department of Justice, not to the head of ATF. but to the Department of Justice, to DOJ in their leadership to be approved. It is essential that we know what was done there and who did it in the process. So this is not some ancillary thing that's added to it. This is an important part of this process. Now, there's all this obfuscation to say it's Bush's fault, this is political, there's not enough witnesses. The essence of this particular contempt deals with the documents that on February the 4th of last year, the Department of Justice sent us a letter that said they had no idea about this, and then by December, after all year long saying, no, we didn't know, we didn't know, we didn't know, come back in December and say, oops, we did. Okay, it is what Eric Holder has called to us his evolving truth. We want to know the facts of how it started here and when here. There's 130,000 documents that they say they have. They've turned over a little over 7,000 of those documents. That is not the prerogative for them to continue to hold and conceal those documents. Fast and Furious has moved to slow and tedious.
Additional 15 seconds.
Gentleman is recognized for an additional 15 seconds.
Fast and Furious has moved to slow and tedious. We have got to have those documents to be able to finish up this investigation. It should have long since been done. Eric Holder told our chairman that he has these documents, but he's using the documents as a bargaining chip to get a better deal. That is not the prerogative when we have a subpoena. We are not looking for some conflict with the administration. We're looking to get to the facts. With that, I yield back.
Gentleman's time has expired. Gentleman from Massachusetts.
Mr. Speaker, I yield 1.5 minutes to the gentleman from Pennsylvania, Mr. Fattah.
Gentleman from Pennsylvania is recognized for 90 seconds.
I thank the gentleman. I served for many years on the Government Oversight and Reform Committee. I've been involved in a lot of these investigations over time. I served for many years on the House Ethics Committee. The Congress should be embarrassed about the conduct of this investigation and the charade that brings us to the floor today. The Attorney General can't provide these documents. The President has protected them under executive order, under executive privilege, which means that the person who works for the President can't provide them to the Congress. We all know that. So to take a decent man who served his country in almost every capacity as a military veteran, as a U.S. attorney here in D.C., as a judge, and to drag his name wrongfully before this House, this majority, which clearly has lost its way. Their pursuit of power, they've lost all sense of principle. This is a disgraceful act, but we will get through it. We are a big country, and the American people will recognize the disservice that the Republican majority brings to this floor today. And I wouldn't be surprised at the end of the day whether we couldn't even find this Congress held in more contempt than it is now. I think we're at 9% approval. That's because of the actions of this majority, and the public will have to take account of that as we go forward. I thank the gentleman.
Gentleman from Florida.
I reserve.
Gentleman reserves. Gentleman from Massachusetts.
Mr. Speaker, I yield to the gentlelady from California, Ms. Spear, 2 minutes.
Gentlelady from California is recognized for 2 minutes.
Mr. Speaker, thank you, and I thank the gentleman from Massachusetts. You know, this should be labeled fast and foolish, or maybe fast and fake. We are not talking about gun walking here. We are doing nothing to help the family of Brian Terry recover. What we're talking about are inter-office emails between the administration executives in the AG's office. I want everyone here to be willing to turn over all of their inter-office emails. But more importantly, let's talk about whether there's precedence for the assertion of executive privilege. And let me just point to a number of cases when executive privilege was asserted for non-involved presidential communications. In 1981, October, President Reagan asserted executive privilege over internal deliberations within the Department of Interior concerning, interestingly enough, Mineral Lands Leasing Act. On October 1982, President Reagan asserted executive privilege over internal EPA files concerning Superfund provisions. On July 1986, President Reagan asserted executive privilege over documents written by William Rehnquist when he was the head of the OLC at DOJ. On August 1991, President George H.W. Bush asserted executive privilege over an internal Defense Department memorandum regarding an aircraft development contract. December 2011, President George W. Bush asserted executive privilege over internal Justice Department materials relating to prosecutorial decision-making. It has been done many times before by Republican presidents. What we are doing here is a travesty to this institution and to this country. I yield back.
Gentleman from Florida.
I reserve.
Gentleman reserves. Gentleman from Massachusetts.
Mr. Speaker, can I inquire for the gentleman from Florida how many more speakers he has? Because we have no more speakers on this side but myself.
We have no more speakers.
Gentleman from Massachusetts.
Mr. Speaker, I yield myself the balance of the time.
Gentleman is recognized for 2 1/4 minutes.
Mr. Speaker, there isn't a single person in this House who doesn't honor the service of Agent Terry. There isn't a single person in this House who does not want justice for the Agent Terry's family and the truth. There isn't a single person in this House, I believe, who doesn't want to get to the bottom of how gun walking started and how these operations were so terribly botched. But every single attempt for an even-handed investigation has been thwarted by the Republican majority. There has not been an even-handed investigation. Every single witness that the Democrats requested to be called before the committee, they were refused. Every single witness. It's unprecedented. Let me say that Eric Holder is a good and decent and honorable man. He's doing an excellent job as Attorney General. He does not deserve this. And this institution does not deserve this. I said to my friends on the other side of the aisle, do you really want to go down this road? This is a race to the bottom. This is a race to the bottom. This is a witch hunt. This is politics, pure and simple. It diminishes this House of Representatives. We are better than this. Does everything have to be a confrontation? Does everything have to be in your face? Now, I get it. You want to maintain your majority. I get it. You want to win elections. That's understandable. But at what cost? Do we really need to drag the House of Representatives down this road? I mean, this is a stain on this House of Representatives. We should not be here today. We should be talking about jobs and putting people back to work and about making sure student loans don't double. But instead, we are doing this. This is so political and so blatantly partisan that I think the American people are sickened by this. And as a number of people have said, you want to know why the approval rating of Congress is so low? You know, watch the videotape of this debate here today. We should be doing the people's business. This is not the people's business. This is not about getting to the truth in the case of Agent Terry. This is a political maneuver to go after this administration. And this has unfortunately become a trend and a pattern in this Congress. You know, we need to find a way to solve our problems without always having these big confrontations. So I urge my colleagues on the other side of the aisle, you know, don't go down this road. Now, we urged the Speaker of the House yesterday to pull this from the floor. This is wrong. Please defeat this rule.
Gentleman's time has expired. Gentleman from Florida.
Mr. Speaker, this is about Agent Terry, who gave his life for this country. This is about what this government has done, not to expose the truth, but to block the truth. This is about calling on the Attorney General to follow the Constitution. This is about us following Article 1 of the Constitution in regards to our ability to have oversight. You know, I hear this stuff about witch hunt and about politics, and it gets me sick. Because I will tell you this, as a former law enforcement officer, we should be more worried about what lousy policies that Attorney General Holder is covering up that caused the death of one of our own in protecting this country. That's what this is all about. This is about holding people accountable. You know, I hear a lot of things down here, but the rule of law. You know, when I was subpoenaed as a sheriff, we complied with the subpoena. Now, I understand that the Attorney General feels that he's above the law in regards to the subpoena. And I understand the President's come to protect him. But we talk about this body and what the American people think. How about we do the right thing? That, Mr. Speaker, that we move forward and do the right thing in regards to all the Attorney General has to do is comply with the subpoena. And by saying that he's bent over backwards, I would suggest to you that under 8,000 pages of documents out of 140,000 is not bending over backwards. This is about our constitutional responsibility to provide oversight. This is about our constitutional responsibility to make sure that the federal government stays on track. that these executive branch decisions that are made don't put more Americans at risk. Nobody seems to care about the 200-plus Mexican nationals that have been killed. Obviously, Mexico cares because they want to indict those that were responsible for coming up with this failed idea. This is about Congress doing its constitutional responsibility, holding hearings to find out what happened. And when the federal government or branches of the federal government stand in the way and obstruct, that's not the right thing to do. My friends on the other side of the aisle should be more concerned that the Attorney General has said to Congress, guess what? You don't matter. Congress does matter. Congress has a constitutional responsibility, Mr. Speaker, to do just that, to have oversight over the executive branch. And merely the subpoena is a tool to allow us to do that. And unfortunately, this Attorney General feels that he doesn't have to comply. I beg to differ. I think the American people, but more than that, the family of Officer Terry deserve to know what transpired and what the end of this is. And I think that we should be protecting those law enforcement officers that are out there today in the United States of America. They're going to be facing these same guns that were walked during Fast and Furious. If you read the transcripts, hundreds of guns walked. Some were recovered in the United States, and unfortunately some have been recovered in Mexico and have led to deaths in Mexico. One has to wonder how many of those guns are going to lead to deaths here in America. You know, when I raised my hand along with everybody else, it was to support and defend the Constitution. When I raised my hand as a sheriff, it was to support and defend the Constitution. And when Officer Terry raised his hand, it was to support and defend the Constitution and laws of the United States of America. We owe it to all of our law enforcement officers, federal law enforcement officers in particular, on this issue, to make sure that they're protected. And to all our local law enforcement officers who are going to be the first line of defense on the streets of this city and counties. They have a right to know what this Attorney General's office has done and the leadership has done, not giving people a free pass because it's expedient to do. And, you know, we really don't want to hear what the absolute facts are. Let's just push the facts aside. Those on the other side of the aisle really don't want to talk about the facts. They want to talk about things that, you know, it's a witch hunt or it's politics. The facts are clear. Officer Terry's dead. Officer Terry died because weapons were allowed to walk from the United States under the nose of ATF and under the nose of the Attorney General's office through an OCDF case. That's the facts. I would suggest that we should find out how did that come to pass, and then, in regards to what was transpired and sent to Congress and members of Congress about the fact that it didn't really occur, and then 10 months later, oh, by the way, you know, that memo we sent wasn't correct. We did, in fact, allow guns to walk. We've put law enforcement officers in the United States of America at risk because this federal government had a botched idea and a bad idea. And with that, I yield back to balance my time, and I move the previous question on the resolution.
Without objection, the previous question is ordered. The question is on adoption of the resolution. All those in favor say aye. Those opposed, no. The ayes have it. The resolution is agreed to.
Speaker, on that, I ask for a recorded vote.
Does the gentleman ask for yeas and nays?
Yes. 8 yeas and nays.
The yeas and nays are requested. Those favoring a vote by the yeas and nays will rise. A sufficient number having risen, the yeas and nays are ordered. Members will record their votes by electronic device. Pursuant to Clause 8 of Rule 20, this 15-minute vote on House Resolution 708 will be followed by 5-minute votes on suspending the rules and passing H.R. 4251 if ordered and H.R. 4005 if ordered. This is a 15-minute vote.
The House is holding the first of a series of 3 votes, beginning with a vote on the rule for debate in the contempt resolution and votes on a couple of suspension bills debated yesterday dealing with port security. We are also expecting a boycott of the contempt vote itself by members of the Congressional Black, Hispanic, Asian Pacific American, and Progressive caucuses, as well as other members of Congress who will walk out off the House floor instead of voting to hold Attorney General Eric Holder in contempt of Congress, in their words, in order to express their strong opposition to this partisan activity. And we'll be watching for that as deliberations continue. While these votes are underway, on C-SPAN 3, we've been covering a reaction to the Supreme Court's decision earlier today regarding the nation's health care law. The court decided 5-4 to uphold the law, with Chief Justice John Roberts siding with Justices Breyer, Ginsburg, Kagan, and Sotomayor in finalizing that decision. There have been demonstrations and speeches happening in front of the court all day since the announcement from members of Congress and advocacy groups. Also, remarks from Republican presidential candidate Mitt Romney, President Obama, and then a legal perspective on the decision from Georgetown law professor Neil Katyal. All that's been shown on C-SPAN 3. We're going to show you right now Mitt Romney, followed by the President, and then Neil Katyal.
As you might imagine, I disagree with the Supreme Court's decision, and I agree with the dissent. What the court did not do on its last day in session, I will do on my first day if elected President of the United States. And that is, I will act to repeal Obamacare. Let's make clear that we understand what the court did and did not do. What the court did today was say that Obamacare does not violate the Constitution. What they did not do was say that Obamacare is good law or that it's good policy. Obamacare was bad policy yesterday. It's bad policy today. Obamacare was bad law yesterday. It's bad law today. Let me tell you why I say that. Obamacare raises taxes on the American people by approximately $500 billion. Obamacare cuts Medicare by approximately $500 billion. And even with those cuts and tax increases, Obamacare adds trillions to our deficits and to our national debt and pushes those obligations on to coming generations. Obamacare also means that for up to 20 million Americans, they will lose the insurance they currently have, the insurance that they like and they want to keep. Obamacare is a job killer. Businesses across the country have been asked what the impact is of Obamacare. 3/4 of those surveyed by the Chamber of Commerce said Obamacare makes it less likely for them to hire people. And perhaps most troubling of all, Obamacare puts the federal government between you and your doctor. For all those reasons, it's important for us to repeal and replace Obamacare. What are some of the things that we'll keep in place and must be in place in a reform, a real reform of our health care system? One, we have to make sure that people who want to keep their current insurance will be able to do so. Having 20 million people up to that number of people lose the insurance they want is simply unacceptable. Number two, got to make sure that those people who have pre-existing conditions know that they will be able to be insured and they will not lose their insurance. We also have to assure that we do our very best to help each state in their effort to assure that every American has access to affordable health care. And something that Obamacare does not do that must be done in real reform is helping lower the cost of health care and health insurance. It's becoming prohibitively expensive. And so this is now a time for the American people to make a choice. You can choose whether you want to have a larger and larger government, more and more intrusive in your life, separating you and your doctor, whether you're comfortable with more deficits, higher debt that we pass on to the coming generations, whether you're willing to have the government put in place a plan that potentially causes you to lose the insurance that you like, or whether instead you want to return to a time when the American people will have their own choice in health care, where consumers will be able to make their choices as to what kind of health insurance they want. This is a time of choice for the American people. Our mission is clear. If we want to get rid of Obamacare, we're going to have to replace President Obama. My mission is to make sure we do exactly that we return to the American people the privilege they've always had to live their lives in the way they feel most appropriate, where we don't pass on to coming generations massive deficits and debt, where we don't have a setting where jobs are lost. If we want good jobs and a bright economic future for ourselves and for our kids, we must replace Obamacare. That is my mission, that is our work, and I'm asking the people of America to join me. If you don't want the course that President Obama has put us on, if you want instead a course that the founders envisioned, then join me in this effort. Help us. Help us defeat Obamacare. Help us defeat the liberal agenda that makes government too big, too intrusive, and that's killing jobs across this great country. Thank you so much.
Governor, do you feel the law is unconstitutional?
Republican presidential candidate Mitt Romney speaking earlier today, shortly after the Supreme Court agreed to the constitutionality of the nation's health care law. House lawmakers have scheduled a July 11th vote to repeal the health care law. That's July 11th. President Obama heading to Walter Reed Medical Center in Bethesda this afternoon. Before he left, he made a statement about the court's decision, and he spoke for just over 5 minutes.
Good afternoon. Earlier today, the Supreme Court upheld the constitutionality of the Affordable Care Act, the name of the health care reform we passed 2 years ago. In doing so, they've reaffirmed a fundamental principle that here in America, in the wealthiest nation on earth, no illness or accident should lead to any family's financial ruin. I know there will be a lot of discussion today about the politics of all this, about who won and who lost. That's how these things tend to be viewed here in Washington. But that discussion completely misses the point. Whatever the politics, today's decision was a victory for people all over this country whose lives will be more secure because of this law and the Supreme Court's decision to uphold it. And because this law has a direct impact on so many Americans, I want to take this opportunity to talk about exactly what it means for you. First, if you're one of the more than 250 million Americans who already have health insurance, you will keep your health insurance. This law will only make it more secure and more affordable. Insurance companies can no longer impose lifetime limits on the amount of care you receive. They can no longer discriminate against children with pre-existing conditions. They can no longer drop your coverage if you get sick. They can no longer jack up your premiums without reason. They are required to provide free preventive care like checkups and mammograms, a provision that's already helped 54 million Americans with private insurance. And by this August, nearly 13 million of you will receive a rebate from your insurance company because it spent too much on things like administrative costs and CEO bonuses and not enough on your health care. There's more. Because of the Affordable Care Act, young adults under the age of 26 are able to stay on their parents' health care plans, a provision that's already helped 6 million young Americans. And because of the Affordable Care Act, seniors receive a discount on their prescription drugs, a discount that's already saved more than 5 million seniors on Medicare about $600 each. All of this is happening because of the Affordable Care Act. These provisions provide common-sense protections for middle-class families, and they enjoy broad popular support. And thanks to today's decision, all of these benefits and protections will continue for Americans who already have health insurance. Now, if you're one of the 30 million Americans who don't yet have health insurance, starting in 2014, this law will offer you an array of quality, affordable private health insurance plans to choose from. Each state will take the lead in designing their own menu of options. And if states can come up with even better ways of covering more people at the same quality and cost, this law allows them to do that too. And I've asked Congress to help speed up that process and give states this flexibility in year one. Once states set up these health insurance marketplaces, known as exchanges, insurance companies will no longer be able to discriminate against any American with a pre-existing health condition. They won't be able to charge you more just because you're a woman. They won't be able to bill you into bankruptcy. If you're sick, you'll finally have the same chance to get quality, affordable health care as everyone else. And if you can't afford the premiums, you'll receive a credit that helps pay for it. Today, the Supreme Court also upheld the principle that people who can afford health insurance should take the responsibility to buy health insurance. This is important for two reasons. First, when uninsured people who can afford coverage get sick and show up at the emergency room for care, the rest of us end up paying for their care in the form of higher premiums. And second, if you ask insurance companies to cover people with pre-existing conditions but don't require people who can afford it to buy their own insurance, some folks might wait until they're sick to buy the care they need, which would also drive up everybody else's premiums. That's why, even though I knew it wouldn't be politically popular and resisted the idea when I ran for this office, we ultimately included a provision in the Affordable Care Act that people who can afford to buy health insurance should take the responsibility to do so. In fact, this idea has enjoyed support from members of both parties, including the current Republican nominee for president. Still, I know the debate over this law has been divisive. I respect the very real concerns that millions of Americans have shared. And I know a lot of coverage through this health care debate has focused on what it means politically. Well, it should be pretty clear by now that I didn't do this because it was good politics. I did it because I believed it was good for the country. I did it because I believed it was good for the American people. You know, there's a framed letter that hangs in my office right now. It was sent to me during the health care debate by a woman named Natoma Canfield. For years and years, Natoma did everything right. She bought health insurance, she paid her premiums on time, but 18 years ago, Natoma was diagnosed with cancer. And even though she'd been cancer-free for more than a decade, her insurance company kept jacking up her rates year after year. And despite her desire to keep her coverage, despite her fears that she would get sick again, she had to surrender her health insurance and was forced to hang her fortunes on chance. I carried Natoma's story with me every day of the fight to pass this law. It reminded me of all the Americans, all across the country, who have had to worry not only about getting sick, but about the cost of getting well. Natoma is well today, and because of this law, there are other Americans, other sons and daughters, brothers and sisters, fathers and mothers, who will not have to hang their fortunes on chance. These are the Americans for whom we passed this law. The highest court in the land has now spoken. We will continue to implement this law, and we'll work together to improve on it where we can. But what we won't do, what the country can't afford to do, is refight the political battles of 2 years ago or go back to the way things were. With today's announcement, it's time for us to move forward, to implement and, where necessary, improve on this law. And now's the time to keep our focus on the most urgent challenge of our time, putting people back to work, paying down our debt, and building an economy where people can have confidence that if they work hard, they can get ahead. But today, I'm as confident as ever that when we look back 5 years from now, or 10 years from now, or 20 years from now, we'll be better off because we had the courage to pass this law and keep moving forward. Thank you. God bless you, and God bless America.
President Obama, at about 12:15 Eastern today, we get this perspective from inside the court. Of course, there are no cameras allowed in the court, but the AP reports this. Today's Supreme Court ruling is spelled out in 6 opinions, totaling 187 pages, and 3 of the justices spent 51 minutes summarizing their views in the packed courtroom as activists on both sides of the issue waited outside. The crowd in the court audibly exhaled when it became clear that the key part of the law, the insurance mandate, was being upheld. Well, as the House continues with a vote on the roll for debating a contempt of Congress resolution against Attorney General Eric Holder this afternoon, we're showing you remarks from the Supreme Court's 5-4 decision upholding the health care law. Georgetown University law professor Neil Katyal argued all 4 of the health care cases before the Supreme Court, and he gave us his perspective on what the court did today.
Katyal was the former acting U.S. Solicitor General, and in that role argued all of the health care cases in the lower courts, including the health care, the 11th Circuit health care case that was before the Supreme Court. And he joins us now by phone. Neil Katyal, can you first of all tell us what your reaction was when you heard of the decision?
Right. Well, I was sitting in the courtroom, and the chief started with a discussion about why the Commerce Clause, which is one of the arguments that the federal government had advanced to justify the legislation, why that was wrong and would be an unprecedented expansion of federal power. And I think many people in the room at that moment had thought that, oh, the federal government's going to lose this. But then he turned to the government's second argument, the tax power argument, and it was very clear from just a couple seconds in that the government had won the case, and the entire mood in the audience had changed markedly. The Chief Justice's opinion, I think, is a quite interesting one. It says that that the Affordable Care Act's individual mandate provision, which requires Americans to have a certain amount of insurance or pay a penalty, the Chief said that functionally is a tax. He said, look, it looks like a tax. It smells like a tax, it quacks like a tax, it is a tax.
Well, I want to get to policy again and the law in just a second, but I'm just curious about your own frame of mind just over those very short seconds, really.
Well, my frame of mind was a little different because the Chief had actually done something very similar 2 years ago in the Voting Rights Act case, which is a big case about the constitutionality of the Voting Rights Act of 1965 that I had argued. And I remember sitting in the courtroom, and there was, again, about 8 minutes of this is unprecedented and dangerous, and I thought we had lost. And then he switched tones all of a sudden, and it turned out that he had read the statute in a way that that allowed us to win. He did the exact same kind of statutory move here, and so I was kind of holding out hope all through that the chief would come our way, and it was nice to see it.
Have you had a chance to celebrate your success today?
No, not really. But I do think that it's not my success. It's really the success of, a lot of men and women at the Justice Department and throughout the federal government that have spent so long trying to defend the statute against, a very respectable attack. I mean, I have a lot of respect for the people who brought this challenge. I think they were motivated not by politics or anything else. I think they were motivated by a vision of the Constitution. And I appreciate that vision. I just don't think that ultimately describes the American Constitution.
Republican members of Congress that we have spoken to so far this morning have called the Chief Justice's interpretation very conservative. Do you agree with that? And if so, can you explain more?
Well, I think that the Chief Justice's interpretation of the Constitution here is one, he does really focus a lot on tradition, and I think that's what led him to reject the Commerce Clause argument. I'm not quite sure that was the right answer.
Nays are 172.
Mr. Hinojosa votes no. Mr. Platts. Mr. Platts votes aye.
On this vote, the yeas are 254, the nays are 173. The resolution is adopted. Without objection, a motion to reconsider is laid on the table. The unfinished business is on the question on suspending the rules and passing H.R. 4251 as amended, which the clerk will report by title.
Union Calendar number 369, H.R. 4251, a bill to authorize, enhance, and reform certain court security programs